Hello student, today we will discuss the next chapter of pharmaceutical jurisprudence, that is intellectual property right. Now, what is meant by intellectual? Intellectual is nothing but the creation of mind, where the intellectual property law gives a people to right to own a profit from their artistic, scientific and technological creation for a designated period of time, where the inventors are granted to variety of intangible assets such as ideas, business methods, inventions, musical piece, literary work, artistic work, discoveries, and different designs, symbols made by them. The primary objective of an intellectual property right is to encourage inventions by promoting their protection utilization so as to contribute the development of industry, which is turn contribute to the promotion of technological innovations and to the transfer and dissemination of technology. There are the various terms which are involved in a intellectual property, which includes patents, trademarks, copyrights, industrial designs, geographical indication, and trade secrets. The first point is patent. A patent is an exclusive right which is granted to the applicant for an invention, which is maybe a product, which may be a process or a new way of doing something, or offer a new technical solution to that problem, where the other person cannot be commercially made use, distributed, imported, or sold a patented invention without the patent or without the permission of that patent owners. The patent is granted for the limited period of time, which is generally 20 years from the filing of date of application. The patent is granted under the Act 1970, which is amended in year 2005. The owner of the patent has a right to decide who may or who may not use the patented invention during the term of protection. Patent owner may authorize other parties to use their invention or on mutually agreed terms, or owner may also sell their rights of invention to another person who then become a new patentee. Once the patent is expired, the protection ends and the inventions enters into the public domain, where anyone can use the invention without the permission from the patentee. There are different patentability criteria. In that, first is a novelty. Novelty means the new concept, where novelty means the matter which disclosed in a specification is neither published in India nor anywhere else where before the date of filing of patent application in India. Where second is the inventive step, means the invention is not obvious to a person skilled in art in a light of prior publication of documents. Industrially applicable means the invention should possess utility so that it can be made used in industry. There are different concepts or different ideas which are not to be a patentable. It includes discoveries, certain scientific theories, certain mathematical equation which can't be registered as a patent, where different schemes, rules, methods for performing a mental acts, mere discoveries of substance as they are naturally occurring in a world cannot be registered as a patent. Invention that may affect public morals or public health that cannot be registered as a patent, where there are different diagnostic, therapeutic, and surgical methods of treatment for humans and animals. Different plants and other than microorganisms or any biological process for the production of plant or animals. To get a patent, there is a procedure for the application or file the registration for the patent, which include filing of application, that is provisional or complete, which include two steps, that is provisional specification and complete specification. In a first step, that is provisional specification, includes titles, written description, drawings, and other samples or model which are to be used in a research work. In a second step, that is the complete specification, which contains title of that research, abstract, written description, that is complete elaborated description of an invention, and again the drawings which are to be necessary, and any other sample model which are to be used in a research processes. The second step is publication, where a patent application will be published on expiry of 18 months after the priority date. The third step is examination. It includes the process of examination which is start on a request which has to be made within a 36 month from the date of priority filing, where after receiving the request from the patentee, the controller shall direct to the examiner by verifying the propriety and correctness of all documents filed with the application. After verification, examiner will give the examination report within a 1 month. If the examination report is adverse, the controller send a notice to the applicant and give him opportunity to correct it. The controller has the power to reject that application if the applicant does not comply with his requirement. After examination, if there is certain party or opposition party may raise question or may oppose that certain kind of research, then the constitution give the equal opportunity to both the parties and make to solve the problem. The last is grant of patent. If the application satisfy all the requirement of Patent Act, the application is said to be in order of grant. A granted patent shall be published in official gazette and shall be open for a public inspection. Trademarks. Now, trademarks is the first statutory law which deals with the trademarks in India, which was came in year 1940. The Act of 1940 were replaced by the Trademark and Merchandise Act in 1958. The amendment in trademark happened in 1958, that is trade related aspect of intellectual property rights. Trademarks are the distinctive sign that identify certain good product provided by a specific person or enterprises. These are the signs which includes word, letter, symbol, logos, shape, audible signs, picture, slogan or combination of others. A trademark serves as a making tool to recognize a product of particular trader. Trademark provide a protection to the owner of that mark by ensuring the exclusive right to use in identify the good or services or authorize another which are to on a return of payment. The functions of trademarks includes it helps in differentiate the product from similar work in a marketplace. If a mark cannot be replied upon a differentiate, it cannot fulfill any other role. It eliminate the confusion and reduce the product search cost. It also helps to identify the product are recognized on the basis of trademarks. It indicates the source and origin of producer's primary functions and establish a connection between goods and peoples. It also advertises the product investment function, not merely as the symbol of goodwill, but often the most effective agent for a creation of goodwill. Where this term for a trademark is about 10 years and it can be renewed after 10 years for the period of 10 years. Trademarks can be a word, can be a logo, can be a symbol, any design, any image, any combination of this element. The office for the registration of trademark is located at Delhi, Mumbai, Kolkata, Chennai and Ahmedabad. The examples which are to be considered as trademarks are Coca-Cola, symbols of IBM, Airtel, symbol of different enterprises including LG. The next is industrial design. where this industrial design consists of creation of shape, configuration or composition of pattern or color containing aesthetic value. Industrial design serves to make any product or item more beautiful and appealing. Industrial design right is a form of intellectual property right which are used to protect the visual design of the object, where this protection is normally lasts for the 10 years. After it can be renewed for the next 15 years. Essentials which are to be essential for the registration of industrial design includes: the design must be a new or must be a original. The design must be applied to the particular article. It must have its visual appeal. It should not have a published before. It should be a new one. The design must be significantly distinguishable from known designs. It should not comprise or contain scandalous or obscene matter. It should not include a trademark or property mark or any artistic work. This design should not include any mode of principle or any construction or anything which is a substance, a mere mechanical device. Where the next is a copyright, where this copyright is a legal concept which is enacted by most of the government. This copyright is a form of intellectual property protection where the person's exclusive right to produce, publish, sell his or her literary and artistic work. The categories of work that can be protected by this copyright law includes literary work such as novels, poems, play, reference book, newspaper, computer programs, database, choreography, artistic work, paintings, drawings, photograph, architecture, maps and technical drawings. In India, Copyright Act 1957 is come, which is to be amended in a year 1999, 2002 and 2012. Indian Copyright Act. Copyright has its origin in 20th century. It is a form of intellectual property which deals with protecting a right of copyright holders, where the main objective of this Copyright Act is to stop a copyright misuse, to help in protecting the right of person who hold the copyright, to encourage the author, music composers, singers to create their original piece of work by granting them exclusive rights. The next point is geographical indication. This geographical indication is an indication which identify goods as agricultural goods, natural good or manufacturer goods or originating. This geographical indication sign is used on a product that have a specific geographical origin. This sign is used to identify the product as originating in a given place, as well as a qualities, characteristics or reputation of that product should be due to the place of origin. These geographical indications are typically used for agricultural foodstuffs, different type of spirits, wines, handicrafts, and industrial products which are originated from their geographic. A geographical indication right prevents its use by third party whose product does not conform to the applicable standard. The example of these geographical indications include basmati rice, Darjeeling tea, Nagpur's orange, Kolhapuri's chappal, or Kanchipuram saris, where the duration for this geographical indication is about 10 years, which can be renewed after the 10 years. The office for the registration of geographical indication is located in Chennai. The last is state secrets. This trade secrets is any practice or any process of that company that is generally not disclosed outside of that company. It includes formula, process, design, sale method, distribution method, consumers profile, advertising strategy, list of suppliers, clients, and manufacturing process. A trade secret can be protected for an unlimited period of time. Some common example of these trade secrets include recipe for Coca-Cola, manufacturing procedure that possess converting a raw material into another usable material. Thank you.